Good afternoon. Before we begin, I want to note that today's program is a moderated discussion. It's not a debate. Our goal is to help the members of the club, the media, the public at large understand what could be a complicated subject, the Wrongful Death Act in Florida. What does it mean? What does it do? What about the recent attempt to change it? Why it faltered? And where do we go from now? We are fortunate to have two highly experienced, skilled attorneys with differing perspectives on the topic to help unpack it, the topic, so to speak. As it happens, and unfortunately, Steve did not introduce me with a part of my bio that says I also write books on the side. I have 4 legal thrillers, 1 historical novel, and when I was a judge for 30 years, I was not allowed to aggressively hawk my books. That was considered unethical. I'm no longer under that restriction. So if you look at it, do. But important to this discussion is I've also written a nonfiction book called Perceptions of Justice, and the theme of that is, why is it that you would look at something and say, yeah, that's fair, and I look at it and say, no, it's not. And I used to teach a course for judges on that, and the idea was, well, you can write a legal, correct order, but you want the people in front of you to perceive it as fair, fairly, at least arrived at in a fair basis, even if they don't agree. So part of what I want to do today is find out why there might be a disagreement, see if you agree or disagree, and think to yourself, well, why? Why do I look at it differently? But in my book, I devote a section to tort reform and specifically medical malpractice. So I'm looking forward to this discussion to see what my fellow panelist members come up with. And I'll also tell you, this is not rehearsed. They have no idea what I'm going to ask them.
Just like a hearing.
Yeah, just like a counsel. You're not seriously trying to tell this court. But I'm going to ask them to do something that's really difficult for an experienced, skilled lawyer to do, especially a trial attorney. Maybe impossible. But I'm going to ask you to answer the questions and address the topic, not as an advocate for a client or for a group of people, but as a friend and neighbor. And we're sitting down to lunch, having a discussion, and pretend that I have the authority and the ability to make it happen. So you tell me what we need to make happen, and we'll do it.
Okay.
In that sense. So let me set the stage a little bit for you. When Florida became a state like most other states, we adopted the English common law as the basis for our law. Under English common law, if you had a cause of action, it died with you. So if somebody killed you through their negligence or whatever, nobody could sue. Not your estate, nobody else, no survivors, etc. Some people thought, well, maybe that's not quite fair. In 1883, Florida passed a law that allowed the estate to sue on behalf of the person that they killed. But the real modern comprehensive version of the Wrongful Death Act came in 1972. And that went along for a while. That allowed the survivors of somebody who was killed by the wrongdoing, negligence of another person to sue for their loss, for that person that got killed. 1990, in an attempt to address what was considered to be a crisis of medical malpractice insurance. The idea being we need to make healthcare accessible to our people, and they're going so high we're losing healthcare professionals, we can't recruit people, et cetera, et cetera. They carved out an exception and said, well, if you're the parent of an adult child, or if you're the adult child of a parent, now y'all going to correct me if I got this wrong, then you don't get to sue. And some people at the time and now say, well, that's not really fair, is it? I mean, just because I'm 40 and my parent dies doesn't mean that I didn't lose the counsel, the comfort, the advice, the companionship that I had. But nonetheless, that was there. So in 2025, there was a bill passed both houses, which was eventually vetoed by the governor. But I'm going to ask my panelists to tell me and tell you what was in that law, what's your perspective of it, the pros and the cons, why you think the governor vetoed it, and where we ought to go from now. So a lot of questions in one.
Me? The bill would have removed what we call the free kill, and that's what these people are. If you die from medical malpractice, which is the fourth leading cause of a death, it's just not going to show up on your death certificate. If you die from that, your damages were capped to economic damages. That would be your net accumulations, your lost wages, that sort of thing. Believe it or not, most people don't have a lot of net accumulations. Most people consume what they earn. So the large value in these cases is the non-economic. So this would have removed this free kill provision, which says that if you die from medical malpractice and you're 25 years or younger and unmarried, there would be a claim. And in some ways, your parents might even still have a claim. I've had a case on that too. But if you are like my own daughter, 31, unmarried, someone commits malpractice on her, they get away with it just because of her age. A lot of people don't find that rational. I don't, obviously. I've had to try cases where some of the children did qualify, some did not. Oddly enough, some of the children, and they had to be fact witnesses in that case to talk about the death of their mom, they actually had a more intense relationship with her because they had known her so long. They checked on her every day. She helped them raise their kids, that sort of thing. But only one of them, the one who was 23, got any kind of claim. Now, her husband had a claim, okay, but the other two didn't. So it's a very irrational law that doesn't make any sense. And, well, let me get you the other part. I'm also a free kill. If I die from medical malpractice, it's going to be a little different because I got some money. But if I was not one of those people and we were just looking at the non-economic value, there would be, my daughter could not get a claim because I am over 25 and I am unmarried. So there's nobody, there's no survivor under the law. So a lot of people find that to be irrational. I do. And I also think it's bad policy because people respect what you inspect. And so if there's no accountability for your behavior, you're probably not going to watch your behavior as closely. So I think it ends up in less safe healthcare for us when there's no consequence for doing it poorly.
Yeah, thank you, Judge Lewis. Thanks, everybody, for having me today. You know, anytime that the legislature is making a determination about how to pass a law and how to write a law, there's always going to have to be some balance and give and take in the system. And when the medical malpractice cases were carved out of the wrongful death statute, it was done in the face of what they believed was a medical malpractice crisis in the state of Florida. So anytime you pass a law, there's going to be someone who is going to be on the outside of that law looking in. Statute of limitations creates a scenario where there could be a barrier to getting access to the courts. Different types of claims allow different types of damages. The problem that we have in the state of Florida is that we have a burgeoning population and we have a shortage of doctors. The American Medical Association just put out a study that suggested by 2035 we'll be 18,000 doctors short of where we will need to be in order to meet the healthcare needs of our citizens. Florida doctors face the highest medical malpractice premiums in the United States of America. In addition to that, the claims that do come in against doctors and hospitals in our state, they face the highest severity of those claims, meaning that it takes more money to settle those cases, and juries award more money in those cases in Florida than in anywhere else in the United States of America. So the question is, why is that, and what can we do to try to help make it a place where doctors want to come, where we can have recruitment efforts? We've been lobbying on this bill for probably close to a decade now. And what I think we need to make clear is that the medical community in the last session, in this session, has not said that we cannot change this law, that we cannot repeal this law. What the medical community has asked for is that if you're going to increase the number of claims throughout the state, then all they're asking for is a reciprocal protection in the form of caps on non-economic damages. 29 states in our country have caps on non-economic damages. And so is there going to be scenarios in which you have singular cases that will inflame our sympathies, inflame our passions, and make us think that this law should be changed? Absolutely. Every single person that takes the podium in Tallahassee in front of the committees, they tell a story that is heart-wrenching. And there isn't anyone in the room that doesn't feel sympathy for them. And that's exactly the reason why we need a law like this. because anytime there's a scenario which inflames passions, there has to be some type of protection on the other side to make sure that when it does go in front of a jury, you don't have a scenario where things get disproportionate. We're seeing more and more nuclear verdicts in the state of Florida. There used to be on average about one a year. In the last 12 months, I think there's already been 7 or 8 in the state of Florida, nuclear verdicts being ones that are 15, 20, 50, $71 million. So the point is that if we are going to repeal this law, that's not something that the medical community stands against. What they're asking for is a reciprocal protection. And if we're not going to have a reciprocal protection, then we can't support a bill that is going to balloon the number of claims in the state of Florida against an already beleaguered medical system.
So let me follow up that question for you, Andy. 1990, and there were caps on damages in a previous legislation, which later was ruled unconstitutional, I think. But there was a period of time when you had caps on damages, you had the limitation on the wrongful death. Did the insurance costs go down?
Well, it's a good question, and so here's a couple problems with the question. First is that what we've also seen over the period of time that you're referencing is a consolidation of healthcare. So physicians are going in-house with large medical organizations, so that's not going to be reflected in individual physician rates from insurers who are insuring individual doctors. The other problem is that any time that we are putting in place things like caps on non-economic damages, like for example, when they passed in the 2003-2004 timeframe, they were immediately under judicial attack. In other words, litigation ensued immediately suggesting that they were unconstitutional. Claims were going up on appeal immediately. And then by the 2017 timeframe, we had already invalidated caps on both wrongful death and personal injury medical malpractice cases. When insurance companies are making decisions about the way that they are going to set rates in the state of Florida or any state in the United States, they're looking at what the certainty might be in any particular scenario. And so when they look at a case where they say, we've got caps on damages, but we haven't even been given an opportunity to see how they might work, because when they're passed, all the cases that were already in the pipeline prior to the law being passed still have to work their way through the system. So if you're immediately attacking the law, you're still seeing those other old cases working their way through the system, and by the time those old cases work their way through, you've already invalidated the caps. Well, then no insurance company is going to make a decision to say that they need to lower premiums in the face of what will inevitably be a return to skyrocketing litigation in the state. So that's something that's oftentimes spoke about. In other words, did the premiums go down? Well, the premiums have to be given a chance to go down because the law has to be given a chance to work its way through the system.
Problem is that the law, though, is in effect since 1990 in terms of who can sue and who can get non-economic damages. Forget about caps on damages. How come that didn't work?
Sure. I think it's a fair question. I think the problem is that anytime that you have a scenario where you have the wrongful death change, where plaintiffs that are the parents of adult children or adult children of deceased parents can't sue, you have to look globally at the medical malpractice system as a whole. At the very same time, there's been skyrocketing new claims that come in every single year. Things like claims of non-delegable duty and agency and apparent agency. In Florida, for example, typically employers are responsible for anything that their employees do. It's just part of the law. It's always been part of the law. And so employers are going to be on the hook. In many cases, the physicians who are practicing in the hospital are not employees of the hospital. They go through a credentialing process. They have privileges, but they're not an employee. But in the state of Florida, there are claims called apparent agency, suggesting that just because the medical malpractice claim occurred within the hospital, that the hospital should be responsible for that as well. And so you have a number of other attacks that are coming in. So will any singular reform completely overhaul or change the medical malpractice system? Absolutely not. I don't think anybody is suggesting that to be the case. But if you slowly chip away at every single protection that comes in, and on top of that, you're adding new claims continually, then the system is never going to turn itself around.
What do you say to that?
I got a lot to say to that.
Okay.
Let me just stop reeling. The insurance companies enjoyed 11 years of those caps and did not pass one premium discount to those doctors. Not one. This is an insurance versus the world crisis. This is not a doctor versus a lawyer crisis. Doctors are going to work every day doing the best that they can, but they're humans and they make mistakes. I insist that they be held accountable and make it right when they do. Anybody got a problem with that? No. That's how we raise our children. Fix your mistakes. And if you can't fix it, replace it. If you can't replace it, pay the full value of what you took from those people. Very simple, okay? The insurance companies scared the doctors, kept taking their money, kept enjoying the benefits of those caps. 11 years they did. And whenever whoever was their spokesperson at the time said, why didn't you pass those premium savings along to the doctors? Because it is too expensive. The malpractice is too expensive, but it's not based on claims. Okay, don't ever listen to somebody tell you there's a frivolous medical malpractice case. That doesn't exist. And do you know why that is? Because I pick my cases. I'm a plaintiff's lawyer. I don't defend anything that falls in my lap and try to come up with some way to get this doctor out of it. I picked this case, and I'm spending my time and the people I'm paying to work on that case for 2 to 3 years. This is another thing with MedMal. They want to make it so hard to get that money you are already entitled to, because their expert told them the same damn thing mine did when we got it reviewed before I ever sued them. They've known they've had to pay on it for 2 or 3 years, and they don't till the last minute. That is a business model set up to make it so hard to sue them that you don't want to do it. I can't find lawyers to work on these cases, okay? I haven't actually practiced in this area in a while because of that. I can't staff them. It's too hard. People don't like to do things that are hard and high risk. And I'm financing those cases myself, the ones that I have interviewed and I have researched and I've investigated a year before that doctor even knows my name. I've talked to other doctors about causation, about damages, about liability, doctors who are at least as trained as they are and as experienced as they are, only they do it in a much better, more esteemed institution than the doctor I'm suing usually. You can't sue a doctor in Florida. There's an entire pre-suit medical malpractice scheme. It's not like slip and fall. It's not like an auto accident. You can't sue a doctor in Florida unless you get another doctor who's willing to risk his reputation, his standing where he is, his peer acceptance, to say, I'm holding my hand up, and I'm saying he messed up. And this time it really mattered because we have a catastrophic result over here. People don't sue in medical malpractice unless it is you either are dead or you got a life care plan, meaning you can't eat, clothe, or bathe yourself. You cannot live independently because it's not worth it. I got to finance this thing for 2 years, pay people to work on it, and I'm loaning my dumb self loans my money I've already paid taxes on in an interest-free loan to finance these cases, these costs. So if I don't win, I'm out all my time and not my actual money, okay? So there aren't frivolous lawsuits. You don't dabble in malpractice. There are these ambulance chasers, these people with the signs all over the place, all these people on cabs, billboards, buses. They don't do med mal. Those are serious lawyers because I got to go up against this guy. He doesn't sound like a clown. Those are the best of the best lawyers. So when you see a medical malpractice case, it's quite serious. The judge can tell you, and you don't see a lot of them, okay? There's something like 3,000 claims that are filed in Florida every year. Do you know how many old people we have in Florida? A lot of them, and they're being disrespected, and there are more coming every day, okay? And the doctors are not leaving because of malpractice claims. They're leaving, and we don't have enough of them because we don't have enough residencies here, okay? Fix that problem. That's not this problem. So, is that enough? You want to keep going?
Up to you. You're doing good.
I'll get hot. Am I flushed?
You might give Andy a chance then to.
Right, yeah. So I look, here's the long and short of it, is that my clients are consistently coming to me saying that if we owe, we want to pay what we owe as quickly as possible and get out of it. They don't want to pay me any more than they want to pay anyone else. And so when there is a claim that comes in, I can assure you that if we get cases that we have experts who say that they're not defensible, the last thing my client wants me to do is spend hundreds of thousands of dollars chasing this case around only to then pay on it later. And I will tell you that conversely, when we talk about pre-suit and no frivolous cases, we have, on the defense side, we also have to have an expert to sign an affidavit that says that the standard of care was met. So what you have is you have a scenario where you have experts who both may be reasonable, who see the case differently. The problem is that when you take a case and you work back through it retrospectively, meaning that after you know the outcome of the case, well, then it becomes much easier to criticize the individual decisions that are made throughout the case. Unfortunately, our doctors don't have that luxury. They don't have the crystal ball to say, if I make this decision, this is how it ultimately turns out. And I will tell you just from experience, I've got dozens and dozens and dozens of cases that don't involve death and don't involve life care plans. There are certain ones that are certainly very serious and they have serious damages. But to suggest that only the most serious of cases are pursued certainly is not my experience.
So if I understand, we got competing public policy considerations. On the one hand, as Dana says, well, this makes sense, that you should be able to recover. We've got a perceived necessity to do something to attract physicians, healthcare providers, to keep them and to bring down the cost so that everybody can have access to medical care, okay? Do you have any other kind of alternative remedy other than taking the ability to sue from people who survive? Is there any other way to address that perceived problem that maybe we could agree on?
Yeah, no, absolutely, and that's what I go back to the caps on damages. I think putting caps on non-economic damages is a reasonable alternative because it provides a reciprocal protection. Let me make sure I understand that that everyone understands what caps on damages means. Caps on damages means that it sets a limit of the amount of non-economic damages, the pain and suffering damages that are a part of a case. So if a case does have a life care plan, and that life care plan says it's $5 million or $10 million or $50 million, the plaintiff can recover every penny of that money in the face of caps on non-economic damages. What it does is it removes that uncertainty component of a case. In other words, that we go in and we can say, the plaintiff's life care plan says it's $20 million, my life care plan says it's $5 million, but what we don't know is what the pain and suffering damages are ultimately going to be. And when we have cases that have come through recently, Tampa General Hospital was recently hit in Tampa, Florida for $72 million, $55 million of which was non-economic damages. There was a $45 million verdict against Orlando Health. All $45 million of it was pain and suffering damages only. So what we're doing is we're taking out the most uncertain portion of the case so that we can then make a determination about what the case value might actually be. Because once those big verdicts come in, the very next mediation that I'm sitting in, guess what I hear about? Hey, we just hit a verdict for $72 million. So the case that we told you yesterday we would take $5 million in, now we want $20 million because of the verdict that just came in. So we need to remove that uncertainty because not only will it help address insurance crisis issues, but it's also going to help cases come to settlement more often. There's certainly been cases that my client has wanted to settle, that has tried to settle, and that we couldn't get settled because we couldn't agree on values. We went into those cases and they turned out to be defense verdicts, meaning that now the plaintiff doesn't get a penny. And that's because we can't agree on values all the time. Caps on non-economic damages help us to agree on values.
So Andy, if we go ahead and restore the right of survivors fully to sue in wrongful death, would you be okay if we had a cap on damages? Would that solve the problem? Could we agree on that?
I do, yeah, I do agree with that, and I think most of the medical community agrees with that, is that we can certainly repeal that law if the legislature and the community at large believe that this is the law that needs to be changed, then we change it, but we put caps on damages, and that can, I believe, satisfy both sides.
What do you say, Dana?
I don't think it's necessary, and I think there's a lot of other things. It's not necessary at all because you're talking about a few aberrant situations, and then there's going to be an appeal, and you're not going to end up paying 72 or 55 million on those cases. You're taking a couple of things and trying to make it representative of the entire situation, and that could not be further from the truth. One thing you're not going to get in a medical malpractice case is one of these phantom defendants where nobody's defending the case and somebody's in the paper the next day saying they just got a verdict for $120 million. Well, when nobody defends it, that's pretty easy to do. I'll take those all day long. You don't have that in medical malpractice. What you do have are jurors that are selected by that side and this side, and he's running the show, and they hear the evidence, and that person in that position makes sure they don't hear a bunch of inflammatory emotional stuff that's going to create an emotional verdict. He's a gatekeeper for that. The judges are, and they do a very good job with that. What you get is people who are put in a job to do a job to listen to the evidence, and this is what they said it was worth after hearing the evidence. Don't set that aside. That'd be like saying, oh, I know these people elected this person, but I don't like him, so I'm going to remove him from office. No, they did their job. Let them do their job. Trust your system. If you don't like the system, change the system. But under our justice system, those jurors hear the evidence. We don't get to just walk into a courtroom and say anything we want to say and inflame that jury. That is not how that goes. If it did, we would be talking about a whole different thing. So why does that matter? Because when you sue a doctor, you know how many times you win as a plaintiff? Maybe 10%. They win 90-something% of the time. Those doctors still have a lot of esteem. That's changing a little bit. Younger generations don't respect them, don't treat them like Marcus Welby. Never heard of Marcus Welby. They got Dr. MD from the internet, and if you don't know more than their internet does, then they are going to think you're a clown. So it's a little different. It used to be when I started this, is this horn on? Because I need to toot it a minute. I got only the third medical malpractice plaintiff's verdict in this venue ever. You know when the first medical malpractice verdict was given in Leon County? 2007. That was the first one. I got the second one in 2010. I got the fifth one in 2011. My point, though, is this. These are rare. You know. You try a case, you're going to lose most of the time. They got every advantage going for them. Those experts I have to get somebody who's willing to do this, despite what it's going to create in their lives to say another doctor messed up. He's going to call the guy who taught him medical school. He's going to call his friend. Of course they're going to. It's nothing to get an expert. Just so you know, I did 14 years medical malpractice defense before I switched sides, so I know of which I speak. What you could do to fix this problem is actually investigate these things. When you sue a doctor, you've got to give a notice of that complaint to the state. And in the 90s, the state would actually open a file and look into this. And they'd give you an opinion. When I had to do defense, I had two files in my office. I had the state file and I had the insurance defense file. We've had so many changes politically. I have had the investigators, they still have a department that's supposed to investigate these things. You do still have to tell the state. But those investigators told me, if you will finance my investigation, I will look into this. But you better give me the records because I don't have a budget. I can't pay $1 a page to even get the records to look at. So you're going to have to give me the records, and you're going to have to give me access to those experts that you're paying $1,100, $1,200, $1,400 an hour to do. That's another thing. This is why it's so expensive and so hard for you to find a plaintiff's lawyer. You cannot find a plaintiff's lawyer to take a medical malpractice case. Try it. You will be searching a very long time. And that's because we have to pay for all this stuff. He's got a client who's a doctor. That doctor will explain the medicine to him for free. His experts are doing a favor for that doctor friend that he's defending, so he doesn't have to pay to even learn the stuff that we have to pay to learn. That's why these cases are so expensive on the plaintiff's side. So when I bring a case to you, I'm quite serious about it. I'm not dabbling in this. But if they would have the state investigate these cases and police themselves, see, doctors don't police themselves. That's how I get my experts. They will literally say, I'm doing this because we don't look out for each other. So if I'm not financing the state's investigations, they don't investigate it. So they're not doing any kind of policing on this. So if you don't get the luck of finding a malpractice lawyer who will look into this for you, you don't have anything. That's why this whole movement right now to turn away this free kill thing is being driven by the families. Not the opposite of those people, not the Florida Justice Association, the families. You know the woman you see on the news all the time for this? I actually wrote her a letter. She came to me when her mother died, and I had to tell her. I was raised by a lawyer who said, I don't care what the legal malpractice carriers tell you to do. If you advertise and you say you're going to help somebody and you can't do it, you better tell them why. So I used to write a 2-page letter when I turned these people down. And I got 1,000 med mal calls a year, just to me. I would maybe look at 10 of those cases, maybe investigate and take 5 of them. That's how rare a good medical malpractice case is. But this woman, I wrote her a letter and I said, I can't do this because this is a free kill. But I gave her a link to Allison Tant's office, I gave her a link to the senator's office, and I gave her a link to the governor's office. I said, go talk to these people about it. And this woman, at thousands of letters I've written like that, took me up on it. So she's the one, Beth, you see her in the news all the time. This is her crusade.
And Judge, if I may, I think if we're looking for common ground, I think we can both agree that if it's an issue of policing doctors through the Department of Health, then that's another way that we can certainly agree to have this issue, meet in the middle on this issue. I've never spoken to a doctor who says they want to make sure that bad doctors are allowed to continue to practice. I must be the worst businessman in America because this is the first time I've ever heard I don't have to pay for experts to tell me and explain the medicine. Because I will tell you that in every single case, I'm paying $25,000, $35,000, $45,000 throughout the course of the case because they are charging me every single time I
you
pick up
pay,
the phone.
you just get a beggar selection.
Well,
No,
so,
they pay.
Yeah, so there isn't any free lunch when it comes to defending a medical malpractice claim. But if the issue is we have to have $72 million verdicts to police medical malpractice because the state won't do it, well, that's something we can agree on. Then let's fund the state agencies. Let's fund the agency so the Department of Health can look into this. And if it's a bad doctor, well, then the Department of Health can take action against that bad doctor's license. The problem is that when we get into a jury trial, it doesn't matter that there are rules that say we can't say overly inflammatory things. You're looking at a family who's lost a loved one. You're looking at someone who's sitting in a wheelchair. You're looking at someone who's in a permanent vegetative state. There isn't a single person anywhere who's not going to feel an immense amount of sympathy for that family. And at the end of the day, what they're ultimately looking to say is, look, how can we turn this family away? How can we say no to them? Caps on non-economic damages allow for when you have those runaway verdicts, when you have that anecdotal case where the verdicts are very high, it allows it to bring it back into alignment so that the jury can continue to do their job. But it also would allow for these families who say that they need this ability to go and sue, it'll allow them to go and sue their doctors at the same time. So there is a trade-off and a balance there.
I need to add one thing about the department. The problem with the state, that's going to help you feel better about your health care theoretically if they investigate these doctors. But that does nothing to compensate the people who've hurt. That's just looking at the doctor's conduct. So that doesn't do anything to make the people who are harmed whole. So it won't solve that problem.
But it could be a nice complementary thing to suing. In other words, we want both of them.
In my experience, it was more of an academic exercise when they did it. Yeah. It was a hoop. It really didn't have any teeth, paper tiger.
Effective. And another problem with that, and that was one of the reasons that Governor DeSantis gave for vetoing the bill was, well, we should do that through accountability, through administrative procedures. But a lot of those times, I don't think it's a bad doctor. Just like it's not a bad driver, but you make a mistake, you're negligent, somebody suffers a loss for it. So there's the chance of somebody being barred from ever practicing law are probably pretty slim in that situation.
Yeah.
But I did have a couple of follow-ups on yours, Dana. One, who is Marcus Welby? No, just kidding on that one. The other is, but you probably, those of you are familiar with the movie The Verdict, Paul Newman, James Mason, medical malpractice case, the lady's in a coma. We get to the end, and if you haven't seen it, I'm sorry, another
spoiler.
Yeah, another spoiler alert. But when it come back, the jury comes back, and they say, have you reached a verdict? Yes, we have, Your Honor. We find for the plaintiff so-and-so against the hospital and the doctor so-and-so, but we have a question. Yes? Are we limited in the amount of damages to what the plaintiff has requested?
That's the best question a jury can ever ask. I love it.
And the plaintiff's
so much.
attorney is like thanking heaven. And
no, you're not limited. Here's a calculator.
Yeah, and that's what he tells them. He says, and in Florida, the jury instruction on that is basically whatever you think is fair and just in light of all the circumstances. So I've had several jurors in jury selection and whatever say, I don't feel comfortable with that. I mean, is there no formula? Is there no guidelines? Is there nothing we can use? We just come out with something, and if you have a really good lawyer who can be persuasive, one jury might give a whole lot more than one that's not quite. So is there some, if not a cap on damages, is there some way we can give jurors guardrails? I think that was another term used, guardrails to protect against the uncertainty that comes with it.
I see your point. Not everybody lights the same fire under a jury. Not every plaintiff presents well. I've had cases where I've had the best facts, and Judy knows this, I had a jerk husband, and everybody hated him, and that saved you a lot of money. So it's your witnesses, it's your lawyers, it's your jury. You know, sometimes you've got somebody like me on the jury who, we're going to have the verdict I want. So I don't know how long we need to be here, but we're going to have the verdict I want. Not everybody's going to be that way. Usually they have a spirit of cooperation. But there's inherent problems in our judicial system, yes. But to suggest that a non-problem, which is there ain't a whole lot of medical malpractice lawsuits generally, much less high payouts on them, that they ever actually pay. So this is a boogeyman that does not exist. So why we're trying to fix it, I don't know. But the fix doesn't need to be, you all suffer. You know what the caps they're proposing are things like $1 million, total non-economic, no matter how many claimants you have. So if you're an only child and your mom dies, you're in high cotton. But if you're one of 7, you know, that's not rational, because I don't have a seventh of the feeling for my mom. You know, it should be looked at individually. Some kids are terrible adult children. You know, they don't really have a claim. They haven't really done anything. Some of them are at their mama's house every day, doing for her every day. Or she's there helping them raise their kids or something. And that is a huge loss. And sometimes we get closer with our parents as we get older. I know I'm close to my child, you know, and just because she's not married and doesn't have kids of her own, there's no consequence for being negligent with her death. And no, Judge, we're not talking about bad doctors. Over the course of however many years I did it on the defense and did it on the plaintiff, I would say there were 3 that I encountered that they needed to be out of the practice. And yeah, to your point, it's usually the other doctors are telling you about them. They don't want them around them either. But most of the time in medical malpractice cases, somebody just had a bad day. And this time it really mattered, and I need them to take care of it. It's nothing more than that. I'm not telling you you're a bad doctor. I'm not telling you to quit. And when I did defense, let me tell you this. These are so unlike any other case because doctors take this so personally. You know, when you sue a doctor, you are coming at them with everything you've got. You're telling them everything they've spent their life on is worthless. They have no business doing this. They're trash. They're horrible. And they take it that way. They don't have any perspective about this at all from a business decision. That's why they fight it so aggressively. They've got to be told that that is not true. When I did defense, we had a doctor one time try to kill himself because he had a patient lose a leg through necrotizing fasciitis that got away from him. Doctors are not bad people. And again, I just want to make sure everybody understands this is not a doctor versus lawyer fight. This is an insurance company mess.
One final question for both of you. I'm going to throw this out. I'm just brainstorming here because it seems like we have 2 conflicting policy considerations. We want to make sure healthcare is accessible, et cetera, et cetera. We want to make sure people have a right to go to court and address their damages. What if you had a panel, I don't care how big, 3, 5, 7, 9, whatever, of agreed upon experts, both lawyers and doctors in this particular field, for example. And every time you filed a case or a claim, you went there first. And they investigated it, like you said, the state might investigate it, but a lot more thoroughly. And then they wrote out a report, and we think there is liability, there's not liability, and we think the damages should be X. Neither side would be bound by that, but it'd be sort of like a proposal for settlement or non-binding arbitration. Mm-hmm. You can go forward, and matter of fact, Dana, if you get past that, in addition to whatever is awarded, reasonable attorney's fees and cost to the plaintiff's attorney at the end, if they don't accept it. On the other hand, if you don't accept it from the plaintiff's side and you go back, you can still go and you can still have a contingency fee, but the jury is given that report. Because like you said, you can get an expert. Mm-hmm. That's not an independent expert. I guarantee you just about any time you can get an expert, it may be harder for you, but you'll find somebody, or else you wouldn't take the case, obviously. So the jury's got two experts, but they're called from one side and one side the other. But if they had a report from an independent panel, the key to this would be something that everybody agreed was neutral, objective, and competent. It wouldn't matter, well, I'm getting my old hack in there, they're going to rule for me either way. I'm throwing it out, just brainstorming. What's your thoughts?
I have a thought. Do you mind if I go? I used to hate that because I am a trial lawyer, and I know if I get in front of that jury and I got the facts on my side and I'm talking to them like I'm talking to you and we're connecting, I know I'm going to get that verdict. So I don't want anything in between me and that. Used to be people would not give you verdicts, and then now they gave you verdicts, but they were stingy, and then now they're giving you real verdicts, the ones that you all hear about in the paper and that you're scared of. It's not common, but again, we're contorting ourselves to come up with a solution that is for a non-problem. I mean, we're not overwhelming the court systems. There's a remedy for it already. Put your evidence up, let the jury decide. There's no reason to carve this out specially but for the people you're dealing with. Doctors, they have big lobbies. They have money to get their way. But having said that, I also happen to live in the world where I can't find somebody to work on these cases. We haven't done medical malpractice in a long time. They're very hard. They're very high risk. A lot of people don't like to see a bunch of their money hung up for 2 or 3 years on a case that they could end up losing. Okay, so nobody has an appetite for it. Your process is going to add another thing I don't get paid for that I got to do and delay my case. However, the way, at least on my side's not working either. We're not holding these doctors accountable because people aren't taking these cases. Even once CAPS left, we stopped doing med mal. The people I know stopped doing med mal. I got about 3 people I will send a good med mal case to right now who will still do them and take them. And those people only do that. They don't dabble in high-end, high-volume auto accident cases stuff. So it's going to cost more, but it is something that I am now open to. I used to argue with Ricky Polson when I was in law school about arbitration. I hated arbitration. Trial lawyers hate arbitration, especially non-binding, and they don't arbitration because you have a whole different set of rules. You don't get your regular rules of evidence and procedure. They can limit you. And so it's one of those things that just instinctively I recoil from, but something's got to give because we're not suing and we're not having enough accountability because it is such a high burden and high expense, and nobody will do it. So if we're really looking for healthcare we can rely on, we want some accountability in healthcare, that could work. So I'm kind of open to it a little bit more than I used to be.
Okay.
But it's going to cost me more money. But it's kind of like a little road to it. Because if I came into a mediation or if I came into a trial having already gotten something like that and it looks good, or at least it's giving you some kind of a tell, you will take it more seriously, because what we tend to do is try to focus group or mock try something and try to impress upon you that, oh, if I go to trial, you don't believe me, you don't believe that because you weren't there. You didn't defend that focus group, so you don't take that very seriously. So it could actually end up getting more people to do this work, actually, in my view.
Just something to think about, but Andy, I'm
Yeah.
sorry, but I'm getting the message here from
Okay.
Steve that we're almost out of...
Yeah. So
All right, go ahead.
I'll just say this, that your idea of panels, I think, is a good one. Other states in the United States use that very system. I know Indiana is one of them that has a professional board who looks at cases before a plaintiff's firm can file them. And I think it's refreshing, what Dana said, is that she doesn't want anything between her and the jury, right? She doesn't want that report in between her and the jury. She doesn't want that extra stumbling block. But I think that it's a necessary thing to make sure that juries have an opportunity to see it. Let me just address this as well. This idea that this is not an issue or it's not something that is facing Floridians today. Aon Risk Services does a survey throughout the United States every single year. Florida has the highest settlements and the highest verdicts out of anybody in the country. The Medical Malpractice Liability Monitor puts out a report every year that says, just purely numbers, who has the highest medical malpractice premiums in the United States? It's Florida. In Florida right now, there is, I've already mentioned the shortage of doctors. In high-risk specialties like OBGYN, there are currently what they call OB deserts in the state of Florida. That means there's 12 counties in the state of Florida where there's not a single doctor, hospital, or birthing center that provides obstetrical care. There's a total of 19% of counties throughout the state of Florida that are considered to be low access to obstetrical care. This is not a fictional problem. This is a problem that is going to continue to exacerbate, and it's going to continue to be a problem. And if our children and our grandchildren want access to care someday, we have to make sure that we're putting ourselves in a position where we can attract new physicians. In Texas, there was someone from Texas came in and testified in front of one of the Florida legislative committees and said that one of the ways that they attract physicians away from Florida is to talk about the tort environment. Texas has a cap on non-economic damages. So hospital organization after hospital organization has come and said that they're having problems recruiting physicians. So there is real numbers and there is real data to suggest that we are already in the midst of a shortage, and that we very well may be going into an even greater shortage moving in to the future. I also want to address the idea that my clients take it personally. You bet they do. You bet they do. They are now they put their entire professional lives on hold for 6, 7, 8, 10 years while they go through training. They work endless numbers of hours in the hospitals because of those physician shortages, and then they have a bill that is proposed to the Florida legislature that says that they are committing free kills. Can you imagine? So you bet they take it personally, and candidly, the defense bar takes it personally as well, because we want to see physicians have the ability to continue to practice. So thank you.
Well, listen, thank you very much, folks. Let's give them all a big round of applause.